Yeah, once again we are going to start business law.
Good morning, sir.
Shall we start or I'll give some 1 or 2 minute break? Do you need any break? No.
No, sir. No, sir.
We'll continue? Yeah.
Yes, sir.
Sure, sir.
Yes. So let me upload my PPT now. Can you see the PPT now?
Yes, sir.
Yes, sir.
Yes, sir.
Yes, we can see.
Yeah. So by this time we have completed all the 4 units. Somehow broad area we have covered, and in details you need to go through the study material. Okay. So lot many things are there, but only few important topics I have discussed, and based on the syllabus, almost everything I have covered, but very shortly. And I will share the PPT today. Okay, whoever has sent mail today itself, I will share PPT. Right. Today we are going to discuss about the two small act. So one is Factory Act, another is Industrial Dispute Act. Okay. Shall we start now?
Yes, sir.
Yeah. So Factories Act. What is the objective of the factory? All of you know what is factory, what is industry. I think almost all of you are aware of it. But what are the objectives of the Factory Act? Why it is required? In examination also, questions are being asked, short question. What are the objectives of the Factory Act? Okay. So what is factory? You tell me, anybody has any idea about?
Place meant for manufacturing of goods.
Yeah, the place, small place, manufacturing of goods. Okay. Here we have mentioned here. I'll discuss about the meaning of factory also. So let us know what is the objectives of the Factories Act. So main objective is to improve health, welfare, and safety of the workmen. Those workmen who are working under the factory, they are underprivileged people, and many of the time it has been seen that their welfare is not taken into the consideration. So Factory Act is enacted to improve the health, welfare, and safety measures. There are three measures: health measures, welfare, and safety measure of the workmen. This is the first objective. Second objective, to regulate by imposing restriction as to hours of work. Sometimes you must have seen that they are exploited. Factory workers are being exploited. They are continuously doing more than 10 to 15 hours work, but they are not being compensated properly. So another objective, to regulate by imposing restriction as to hours of work. There has to be some restriction. Beyond that, they should not work, including rest and provision for availing of leave. There should be some provision for rest and provision for availing leave also. To maintain all these things, this Factories Act is enacted. Another objective is to make stringent provisions as regards employment of women and young persons and duration of their work. It is again exploitation. You must have seen that many small kids, small children are working who are minority of the age, like some Bengal industry in Firozabad, glass industry, then sometimes carpet industry, small. You can say that. Kids are being employed in that work for to restriction on that, and sometimes women where they are not supposed to the work, it is hazardous for them, still women workers are working. So restrict all those things, this Factory Act is enacted. What is the first objective? To improve health, welfare, and safety measure. The second objective, impose restriction on hours of work, including rest and availing of leave. The third objective is stringent provision as regards to the employment of women and young person and duration of their work. So let us see what is the meaning of the factory. Factory means any premises, including the precincts thereof. That means any place where in 10, sorry, wherein 10 or more people, wherein 10 or more workers are working or were working on any day of the preceding 12 months, and in any part of which a manufacturing process is being carried out on which the aid of power. So, where any places where 10 or more workers are working or were working, previously they were working any day of the preceding 12 months. Preceding 12 months and before 12 months, any day they were working, 10 or more person are working or were working. Any part of which a manufacturing process, the place where manufacturing process is going on with the aid of power, some electrical power or something, or is ordinary so carried on. This is called factory. So where 10 or more workers are working in or were working on any day of the preceding 12 months, and any part where some manufacturing process is going on with the, if it is the with the aid of power, then 10 or more workers. Then another one is the where 20 or more workers are working or were working on any day of the preceding 12 months, on any part of which manufacturing process is being carried out on without the aid of power. Here, without the aid of power, there is no aid of power. So 20 or more people, like banking industry, etc. 20 or more workers are working. Here, 10 or more workers are working with the aid of power is called as factory. Is it clear? Now, licensing and registration of factory. How to get license and register for the factory. The state government may make rules regarding the submission of plans and approval, licensing and registration of the factories. The state government, they may give notification regarding the submission of plan or application for the approval of licensing. All the state government, they have provision. The site chosen to locate the factory must have the previous permission in writing of the state government or chief inspector of the factory. The site which you are choosing for manufacturing process, that should have taken permission, previous permission in writing from the state government or chief inspector of the factory. Before registration, you should have this place of working or place of manufacturing. The site chosen locate the factory must have the previous permission. The third is such permission will be granted to applicant unless he hold duly complied with the direction of the government. You have to follow the rules and regulation direction of the government. As per that only you have need to apply. Every application must be duly accompanied with a certified plan. You should have certified plan of the factory showing all the details together with a challan representing the fee payable for such registration. Whatever the registration fee, that should be paid through challan and licensing or renewal licensing. If it is a licensing payment has to be done or fee has to be paid, or if you are applying for renewal of licensing, then you need to pay that amount. So every application must accompany with a certified plan of factory. It should show all the details together with the challan, all the details, and challan should be there to pay the fee. If permission is not granted either by the state government, you have applied to the state government. So if permission is not granted either by the state government of the chief inspector within 3 months from the date of submission of such application, permission is presumed to have been granted. If you have applied with proper procedure and with proper fee, proper application with certificate plan and certified plan, then the place of working, everything is proper, then you have applied, and within 3 months, if you are not getting any reply from the government or the chief inspector of the factory, that means it's presumed that you have been granted. On the refusal of the state government to grant permission, the aggrieved applicant prefer to appeal for the 30 days from the date of refusal. If it is within 3 months, they are not responding to you, that means it is granted, you can start. Otherwise, if there is a refusal, if they send any refusal letter that you cannot do, then you can go for appeal within 30 days from the refusal. Within 30 days, you can go for the appeal. Every order refusing to grant permission or license must be a speaking order. A speaking order in an order passed after hearing both the side, and it is passed with the reason stated. Every refusal, they should have reason. Both the parties have to be together and they should discuss, and what is the lacuna, it should be discussed and to be mentioned that this is the reason why your permission is not granted. And license or permission cannot be denied merely on the direction of the government without hearing the applicant. You cannot deny without hearing the applicant. You should ask the applicant what is the reason, what is the justification for this one. Then only you can deny. If it is not satisfied, then you can deny. Otherwise, without that, you cannot simply deny to start the factory. Next, licensing and registration factory. Then notice period. The occupier must give 15 days notice to the state government of chief inspector of factory before begins to occupy or use any premises as a factory. If you are going to use any premises as a factory, so prior 15 days notification you should give it to state government or chief inspector of the factory that I am going to start my business here. It is essential to intimate by notice the inspector with a copy addressed to the chief inspector of the factory. It is necessary to intimate and give notice to the inspector with a copy addressed to the chief inspector of the factory. If any new person is appointed as a manager in a factory, if you are appointing any new manager in your factory, then it is necessary to inform the chief inspector. First, you need to give the intimate to the inspector, and a copy you need to forward to the chief inspector of the factory, so that they should know that who is the new manager or new person in this factory. Next is penalty provision. If when a factory inspector is prevented or obstructed from exercising its power, such person shall be punished with imprisonment for 6 months or fine up to rupees 10,000. So it is the duty of the inspector of the factory to visit the factory and to see that if everything is going on all right, or if all the provisions are followed or not. If you are restricting him, if you are not permitting him to visit the factory, then you will be punishable for the 6 months or imprisonment for 6 months or fine up to 10,000 rupees or both. Certifying surgeon. Another provision is certifying surgeon. With the approval of the state government, a certifying surgeon may be authorized and qualified medical practitioner to exercise any of the powers used by him. So a certified surgeon should be appointed, and with the approval of the state government, he may be authorized and qualified medical practitioners to exercise any of his power. He can use his power. Certified surgeon, if it is appointed by the government, then he has the power. Then what are the provision health provision are maintained or not, he has the power to check it. So these are the regarding licensing of the factory. Now, as we said that the objective of the factory, first objective to provide health, safety and welfare measures to the workers. What is the health measures? Here I have mentioned the sections. You need not to mention section. You just write on the point only. So health section is 11 to 20. First is cleanliness. You need to keep your factory neat and clean. There should not be any spoilage or anything which will be harmful for the cause damage to the workers they are working, or it will be a problem for the workers. It should be always neat and clean. So housekeeping staff is appointed for the making the cleanliness of the factory, and you need to keep it is always steady and clean. Disposal of waste and effluent. There should be provision of disposal of waste and effluent. You should dispose it properly. It should not be just thrown out. It should be properly disposed. Then dust and fumes. There should be dust and fume provision should be provided, because this is a control device which will be clearing the air, and it will be purified air will be there. So dust and fume should be provision should be there to remove the dust and fumes. Then ventilation and temperature. It should be proper temperature to be maintained so that it should not be too hot or too cold for the workers who are working. It should be comfortable for them, and proper ventilation facility should be there. Next is artificial humidification. So artificial humidity, if humidity is more, then for maintaining the proper humidity, artificial humidification to be maintained. Then overcrowding. So at least 350 cubic feet per person should be maintained. The total number of employees or workers, and per person 350, minimum 350 cubic feet. Uh, uh, 350 it was, and then later on it changed into 500 cubic feet per person it should be provided. Next is lighting facility. There should be proper lighting facility so that workers they can work properly. Drinking water facility should be provided to the workers, and where drinking water kept properly, direction is to be made, and drinking water, the board is to put that, tag is to put that signboard that drinking water is available here. Then latrine and urinals, this facility is also to be maintained in the factory. The spittoons, so spittoon should be provided so that it will be used to make it neat and clean the industry area. So these are the health measures. So out of these three measures, one long question comes. Normally, it comes either health measure or safety measure and welfare measures. So this is about the health measure. Detail of it, you can go through your study material. Then we'll search about to safety measure. What are the
Sir, one doubt, sir.
Yeah.
Sir, actually, who will ensure that all these things are all maintained properly on a regular basis? Who will ensure that, sir? Because workers, if they face problem,
Okay.
who will come in from the government side? Who will inspect this periodically and
Inspector
with
of
an
the
allegation?
inspector of the factory is appointed.
Factory, he has to visit the factory regularly, sir.
Yeah, you can put a complaint to the inspector of the factory, give it
Okay.
to the chief inspector of the factory. They will immediately they will take into action. Even the certified surgeon is there to complain health measure. If any issue is there, you can complain to the certified surgeon. So
Yes, sir.
the manager will be responsible for this one. So manager, whoever is the manager, their name is to be given to the inspector of the factory. So they should
Okay.
know that who is the right manager. If any complaint comes, they will contact with the manager and they may visit.
Yeah, sir. Thank you, sir.
Yeah.
So during
Next is-
examination, sorry, sir. So, during
Yeah.
examination, whether these sections are also mandatory to write or those
No,
are
not
optional?
necessary. Not necessary. Section
Okay.
need not to write.
Okay, sir.
Okay.
Okay, thank you.
Just for reference only, we have given this. You are not law student to remember all those things. So only points if you are remembering, that is enough. What are the measures? What are the safety measures? Safety is prior to security. According to this concept, the present Factory Act ensures several safety measures as found in section 21 to 40, which are enumerated below. So total 21 to 40, it comes under the safety measure. First of all, fencing of machinery, where heavy machineries are working, or if any means there is a chance of any kind of difficulties or any kind of problem, it will be a dangerous for the worker. So in that case, the machinery has to be proper fencing has to be done. Work on a near machinery in motion, where there is a machinery in motion, there should be proper red mark is to be mentioned, so that workers should be aware that machine is in motion, which will be dangerous. Employment a young person, dangerous machine. You should not allow the young person to working the dangerous machine. You should be the person who is working, they should be properly trained and should work under this machine. Self-acting machine, there are some machines which are self-acting, it can be used by the properly trained person. Casing of new machinery, when new machinery comes, the proper casing has to be done there, so that overheating or sometimes without knowledge, worker may touch it, or it may be dangerous for them. So casing is to be provided. Provision of employment of women and children near carton openers. So there is a provision for employment of women, children near carton opener, because it will be very hazardous to the women and child workers. So cotton, yeah, they should be avoided to work in those places. Hoist and lift, there should be proper, if heavy items are there to lifting that one, proper lift has to be mentioned. Lifting machine, chains and ropes, and lifting tackles. So all this machinery should be there to where the heavy work is going on, to lift those things easily, comfortably they can be. And revolving machine, where revolving machine is there, there should be proper care has to be taken, so that the proper safety measurement has to be taken. These are the few sections about the safety measure. The another one is health measure. These are the three very important topic in factory guide. One is the objective, second is the licensing, how to take the license, the third is the what are the three different measures: health measure, welfare measure, and safety measure. Welfare measure is sitting facilities. There should be proper sitting facilities in the factory where the workers are working. For them, properly sitting facility or rooms has to be there, so that they can take rest. First aid appliances. There should be, there must be first aid appliances in case of any emergency. First aid can be used, and proper. It should be kept in proper place and demarcated that first aid is here. Canteen facilities. There should be canteen facility where more number of workers are working in that place, so that they can take the benefits of canteen. Shelters, restrooms, and lunchroom. There should be shelters, restrooms, and lunch rooms. Lunchroom for the taking lunch, and restroom where for female workers also there should be separate restroom, and shelters are to create a crash. Crash is when the female workers are doing the small kids for taking care of the small kids. The crash facility should be there. Then welfare officer. There has to be a welfare officer who can be taken care of the welfare of the workers. Next is working hour. What is weekly hours? No adult worker shall be required or allowed to work in a factory for more than 48 hours in a week. So in a week, no worker should be allowed work more than 48 hours. At present, it is reduced to 40 hours. Earlier, it was 40 hours, 48 hours. Now it is 40 hours. So no worker should be allowed to work more than 40 hours in a week. Daily hours. No adult worker shall be required to or allowed to work in a factory for more than 9 hours. Maximum, you can allow them to work up to 9 hours in a day, and 40 hours in a week. If 9 hours in a day, it should not cross more than 40 hours in a week. However, to facilitate the change of shift, this limit may be exceeded, subjected to the previous approval of the chief inspector of the factory. If you have shift system, so like 2-hour shift, 3-hour shift, or 4-hour shift, it may exceed more than 9 hours. But for that, you need to take previous permission from the chief of the inspector of the factory. In shifting shift facility, what is there? At a time, you are not working more than 2 or 3 hours. So if there is a 3 shift like that, it may be 9 hours or plus more than that. Sometimes it cross more than 9 hours. For that, you need to take the permission from the chief inspector of the factory. This is all about the Factory Act. Any doubt or anything you want to clarify? Because once we complete this one, then we'll go for this old question paper, 1 or 2 old question paper we'll take, we'll revise it.
Weekly, how many days, working days, sir? Weekly, 5 days, sir? Weekly 5 days means 8 hours only it comes, 40 hours means.
Yeah, that
Right,
is
sir?
up to the factory where if 5 days
Because
working
you are
hours,
saying it should not exceed 9 hours. Then they have to work in a day 8 hours. 8 hours into 5 days, 40
okay.
hours it comes to.
Yeah, it comes.
They work extra, what will happen, sir? They will be paid double wages, sir.
Yeah, OT they pay, but for that overtime they pay, but for that you need to take permission from the chief inspector of the factory.
Okay, sir.
Like shift hour, shift duty, 4 hours. If we are 3 shift, then 12 hour, it will become 12 hours.
Yes, sir.
So in that case, or 4 hour, 3 hours means 12 hours. In that case, you need to take permission of the chief inspector of the factory that this is the provision we are taking, and monthly we are not crossing, or weekly we are not crossing more than that. So like that, there will be the provision is to be made, and you need to manage it.
Yes, sir. Thank you, sir.
Yeah. Next is industrial dispute. What is industry? Most of you are working in industry. Can anyone tell what do you understand by industry? You have understood now what is factory, isn't it?
Yes, sir.
Any idea industry?
Group of factory is known as
Sorry?
industry.
What is your yeah? It is industrial relation or industrial dispute? It is ID Act. Uh, Company law. Next is yeah. Next is and scope for the Industrial Dispute Act.
Those industries which are engaged in large production, sir.
Yeah. Just a second. Let me take it. Industrial Dispute Act. Yeah, where continuously work is going on, and it's a large
Engaged in large production, sir.
large productions are going on.
Like Ashok Leyland, Ennur Foundries.
Yeah. Then what is industrial relations? It is, as
Sir,
you know, that
there
when
are several relationships, sir, between employees, employees to employees, employees to employers,
yeah,
and employees to government. So, a lot of relationships are there.
yeah. So industrial relation is a dynamic, developing concept. It refers to the general web of relationship normally obtaining between the employer and the employee. There should be good relationship. As you said, employee and employee. There should be good relationship between them, interpersonal relationship. So if anything, anytime they will be helping to each other, so work can be uh, carried out smoothly. Similarly, employers and employee, there is a good relationship, then working atmosphere will be better. Otherwise, what will happen if there is no good relationship with employer with employee? Then what will happen? What will be the consequence?
Production will be low, sir.
Sorry, production will be low. Why? Because they will not be motivated. Sometimes they go for strike. Sometimes they go for the slowdown of work. So many things will happen. So there should be proper relationship between the worker and employer. It includes the complex relation between trade unions and management. That is the reason there is a provision of trade union. Every industry there are the several trade union. Any example of trade union anybody can give? Any trade union name?
Intech,
Sorry?
Intech.
INTUC is there, sir. INTUC.
Yeah, INTUC.
Yeah, that I think
BMS,
that is the
Bharati
oldest
Mazdoor
one.
Sangh.
There are so many trade unions which have to be registered and should be properly approved. So through the trade union also, if any dispute arises, you can go through that one. So to maintain the industrial relation, trade union also plays a very important role. Industrial relations are integral aspect of social relation arising out of employer-employee interaction in modern industry. That is why the participation of employees also in many of the industry, topmost industry, they what they do while making any decision, they consider the employee. They invite the employee, leader of the employee, to take part in the decision making process, so that there should be proper relationship and transparency to be maintained, so that there won't be any dispute. The harmony should be maintained. Interest group in industrial relation. Who are the interest group? They are the workers and the organization. There may be conflict between workers and the organization, so this is the interest group. Then it can be manager and their organization. So manager and the employers and their organization, the government. These are the three parties in dispute. Now we come to our Industrial Dispute Act. What our syllabus says, that Industrial Dispute Act 1947. What are the objectives? So all the acts are enacted for certain objective, to fulfill certain objectives. Similarly, Industrial Dispute, what are the objectives? Promoting measures for securing and preserving amity and good relationship between employer and workman. To promote good relationship between employer and employee, so that proper harmony to be maintained. The next objective is inquiring into any matter connected with a relevant to an industrial dispute, promoting the settlement industrial dispute. There should be some settlement process. If at all any dispute arises, there has to be some settlement process, so that dispute can be redressed. The next objective is to adjudication of industrial dispute. If any dispute arises, that to be adjudicated. A reference of individual dispute to grievance settlement authority. So there should be grievance settlement authority who can redress the grievances of the individual or group. Volunteer reference of dispute to arbitration. There has to be voluntary reference to the arbitration. So both the party can sit together and can be arbitrated. So if arbitrator is appointed. Prevention of illegal strike and lockouts. So there won't be any illegal strike and lockout. If proper rules are enacted, laws are enacted, so these are the legal way where the employee can go for strike. This is the illegal way. So they cannot take. So as per the provision, they have to follow. So legal strike only taken place. And lockouts. Lockouts also, who does lockouts? Employee or employer?
Employer.
Employers. So employers may lock out if they will threaten the worker that will lock the industry or lock the factory or lock the industry. So employee will not be able to work. So to prevent all this, the law has been enacted. Compensation for layoff and retrenchment of workmen. If any layoff is there, layoff means due to shortage of coal or power or something, the industry is closed. In that case, there should be proper compensation. If you have laid off, then it doesn't mean that worker will be or employee will be responsible for that. In that case, there should be proper compensation facility. And retrenchment of workmen. Many of the industry retrenchment goes on. So in case of retrenchment, you need to compensate suitably. Provision of the payment of wages from the date of the award till the suit pending before courts of law is decided. If any case is gone to the court of law, there should be provision for payment of wages. It is not that the matter has gone to the court and will stop paying you. It cannot be. So there should be proper provision for the payment of wages from the date of the award. I request all of you to kindly mute your mic because it is disturbing. Mr. Jayabalan, can you mute your mic, please? Mr. Jayabalan, can you mute your mic, please? Yes. Okay. Next, reference of individual issue. Next is arbitration, prevention of illegal strike and lockouts, compensation for layoff and retrenchment of workmen, provision for the payment of wages from the date of the award till the suit pending. If it is pending till the date of award, the wages have to be paid to the employee. prevention of unfair labor practice. There should not be any unfair labor practice. To restrict all these things, Industrial Dispute Act 1947 has been enacted. So what is industrial dispute then? It means any dispute or difference between who are the parties? Employer and employer. If it is between employer and employer. If it is between employer and workman, or workman and workman, which is connected with the employment. It can be terms of employment or non-employment also. It can be terms of employment, the condition of labor of any region. These are the region where it may be connected with these regions. Individual and collective, this is for the workmen as a group. Here individual and collective dispute. The industrial dispute may individual dispute, it may be collective dispute. It may be individual grievances or it may be collective grievances also. Say collective dispute may relate to any of the following matter. What is that collective dispute? What for you are going for collective dispute? It may related to the wages of the employees, bonus, regarding bonus, profit sharing, gratuity, compensatory, and any other allowances. For that, you collectively they may go for collective dispute. It may create the collective dispute. It may be related to hours of work, leave, the wage, holidays, rules and discipline, retrenchment of workmen, closure of establishment, rationalization. These are the collective dispute. It may be related to financial causes like wages, bonus, dearness allowance, traveling allowance, leave with pay, gratuity, holiday. These are related to financial causes. Non-financial causes like transport, housing, education, working hours, working condition, discipline, recreation facility, etc. These are the non-financial reasons. It may be due to financial causes or may not be due to it may be non-financial causes also. What will be the effect of industrial dispute? As I told you, if there is not harmony, no harmony is maintained in the industry, then there will be conflict will be rising, due to which effect of industrial dispute is strike, layoff, lockout, retrenchment, closure, gherao. These are the some effects of industrial dispute. This is also one of the important question in examination in cause of what are the effects of industrial disputes. So the effect of industrial disputes are strike, layoff, lockout, retrenchment, closure, gherao. What is strike? It means cessation of work by a body of persons employed in any industry acting in combination, or a concentrated refusal of any number of persons who are or have been so employed to continue to work to accept employment, or a refusal under a common undertaking of any numbers of such persons to continue to work or to accept employment. These are the kinds of strike. They may stop working, a group of people or all the people they may stop working, or they have given a common undertaking not to work number of days. Similarly, layoff. Layoff means the failure, refusal or inability of an employer on account of the shortage of coal, power or raw material, or the accumulation of stocks, or the breakdown of machinery or natural calamity, or for any other connected reason to give employment. If an employer refuses to he fails to continue the work in the industry, and in that case it will be called as layoff due to shortage of, it may be due to the shortage of coal, it may be due to the shortage of power, raw material, or breakdown of machinery, etc. This is called closure. Similarly, lockout, it means temporary closing of a place of employment, or the suspension of work, or the refusal by an employer to continue to employ or any number of persons employed by him. If he lock down the industry and he refuses some of the workers, all the workers, to give employment or continue employment, under the present definition, two alternative acts of the employer constitute a lockout. What is that? Temporary closing, that means or suspension of work, or refusal to continue employ any number of persons employed by him. These are the temporarily they can close, or they can refuse any number of persons to continue working. Next is retrenchment. The terms are used in the Industrial Dispute Act means termination by the employer of the service of a workman for any reason whatsoever otherwise than a punishment inflicted by way of discipline. Punishment is different thing. Except punishment, if the employer terminates any employee due to any reason, other reason, maybe due to his inactiveness or non-performance or something like that, that is called as a retrenchment. Next is closure. What is closure? It means the permanent closing down of a place of employment or part thereof. That is called closure. Next is gherao. Gherao means encirclement of a manager to criminally intimidate him to accept the demands of the workers. Normally in industry, what has happened? Some of the like group leaders or some union leaders, what they will do, group of people, they will go and gherao the manager to and compel him to accept their demand. So that is called gherao. So these are the various effects of the industrial dispute. Next is this is also one of the question. What are the administration under the Industrial Dispute Act? I think this Minimum Wages Act is not there in your syllabus. We will not discuss ideal fair wage. We will not discuss this one. So Industrial Dispute Act is the last one. So what are the authorities like administration under this Industrial Dispute Act is? First is works committee. So works committee has to be there to just to one second. We'll delete this one. This is not in your syllabus. Otherwise, unnecessarily. Ideal living, real living. Yeah. Administration under this is first is works committee. There has to be works committee so that there will be, if there is any dispute, it has to be taken to the work committee. They can settle the dispute. Next is conciliation officer. There has to be a conciliation officer who can redress the dispute of the workers. Next is board of conciliation. If it is not resolved by the conciliation officer, it would go to the board of conciliation. Board of conciliation, number of arbitrators will be there. There it can be discussed and can be settled. If it is not settled by the board of conciliation, it will go for court of inquiry. It is step by step proceeding further. Court of inquiry is to be taken place. What has happened? Who is responsible? What is all these things? It is to be done. Then, if it is not redressed by the court of inquiry, it will go to the labor court. Finally, it will go to the labor court. And if it is settled by the labor court, fine. Otherwise, it will be again. It will proceed to the industrial tribunal. There has to be a tribunal. Any idea of the tribunal? What do you understand by tribunal? Court and tribunal. Any difference? Any idea about tribunal?
So tribunals are dealing in a particular case of that act only.
What about court?
Courts are generally dealing all laws related issues.
Yeah, there is the one main difference is the court is the this legal body where you have to all the procedure to follow and go. Tribunal is where it is tribunal for the easy settlement of the quick settlement of the dispute, where you can see that retired judges or somebody will be there and administrative person will be there who knows about administration, and judiciary body will be there. So easily, quickly it can go to the, you have the option either go to the court or tribunal. So in industrial dispute case, to easy settlement of the dispute, there is a tribunal is constituted, where both the judicial body and administrative body will be there, so that easily it can be redressed quickly. So it is industrial dispute, then national industrial tribunal, then higher body, the highest body is the national tribunal. If it is not dispute settled by the industrial tribunal, it goes to the national tribunal. This is the administration body under the Industrial Dispute Act. So we have discussed as per the syllabus, almost I have covered, even in short, but I have covered all this. So in details, you can go to the study material. And now we'll go see the one or two old question papers, whether you are able to, you will be able to write it or not. Let us see. Okay. Or any doubt in this one, anything you want to clarify?
No, sir.
Okay, business law. One of the paper I will upload now. Let us see. Can you see the question paper now?
Yes, sir, it's visible.
Yeah, let us see. It is visible.
Yes, sir, it's visible.
This is the, you can see one of the question paper. This is 2023 on June 2024 question paper. June exam only. What they have done? Answer any 5 questions. Distinguish between contract and agreement. Can you write? Can you write the difference between contract and agreement?
Yes, sir.
Yeah. What is a contract?
It's legal.
Legal document.
Legal document. We discuss so many things. What is a
Agreement which is
contract?
enforceable by law.
And
Simple.
contract enforced by.
An agreement enforceable by law is a contract, isn't it? Okay, this is a very simple question. You can kindly go through this statement. Distinguish between contract and agreement. All agreements, all contracts are agreement. All agreements are not contract. Right or wrong?
Yes, sir.
Right, sir.
Right, sir.
Yeah, cite an example of quasi contract. Can you write quasi contract? I have discussed this with example. Quasi contract.
Yes. Yes, sir. Yes, sir.
Somebody should not take the advantage from others. Okay. For example, you left your bike with somebody's your friend's house. After a year, you have approached him to get your bike back, and he has maintained something, and you are supposed to pay the maintenance charge. Describe the types of voidable contracts. We have discussed in PPT also. It is there. I'll share the PPT. Infer the essential of a partnership. This is also we have discussed in PPT already there. What are specific goods in Sales of Goods Act? Give an example. Study material, it is there already, but in PPT not there. Kindly go through this. Mention the privilege of holder in due course. This comes under the
Instrument, negotiable instruments. Sir.
This is comes under the Negotiable Instrument Act. State the objective by issuing a prospectus. Yesterday we have discussed what prospectus. What is the objective of issuing prospectus?
To provide details about while going for public offering.
Yeah, public when advertise for the public share. In that case, you need to release the prospectus so that the investor they should be able to know what is the function of the company, what is the objective, and why what they are supposed to do. Explain the procedure of registration of a company under Company Act. Will you be able to write?
Yes, sir.
We have
Yes, sir.
discussed what are the fundamental documents, what are the things you need to register, what is the fee to be paid to the register of the company. Then what is a breach of contract? Describe the remedies to breach of contract. This is also PPT we have discussed in detail. Summarize the rights and duties of the partners in a partnership firm. This also it is their sharing of profit, then sleeping partner. All this we have discussed in detail. Kindly go through the study material also. Discuss the essential element of contract of sales of goods. Classify the types of negotiable instrument and outline their characteristic. Can you write? What
Yes,
are the
sir.
negotiable, what are the different negotiable instruments?
Check.
Check,
So check, bill of
Bill
exchange,
of
Bill of
and
bill of exchange,
promissory note.
promissory.
promissory note.
So you can write the characteristic also. What is a check? What is promissory note? Will a bill of exchange? We have discussed about the differences also. So I hope you will be able to write. Illustrate the contents of memorandum of association. What are the contents in memorandum of association? What are the various clauses? Contents or clauses? Anything comes, you can write. What are the clauses? What are the content?
Sir, name clause, objects clause,
Yeah.
then
First is name clause.
registered office
Liability
clause.
Name clause first. So register office name, name of the company, then object clause,
Capital clause,
then
then association clause.
I don't know where from you are bringing all this association clause, where it is there. What are the main clauses? 4 clauses I told you.
Name clause, registered office clause, object clause, liability clause.
Yeah. First one is name clause. You can name clause, then register office clause, then object clause, liability clause. These are the 4 important clauses in the memorandum of association. Okay. Name clause, what you need to do, name of the company, and it should be at the end of the company limited. Registered office clause, where is the registered office, what is the address where people can go and see the documents. Object clause, what are the objects of the company. So what is ultra virus? What is ultra virus?
Lifting the veil.
Something which is against the objective of company.
The object of the company. Okay. So where we are there, negotiation contents of memorandum of association. You can write contents of memorandum of association. Explain
Yes,
the
sir.
modes of winding of a company. We have discussed yesterday. Modes of winding up, volunteer winding up, compulsory winding up, isn't it? Describe the provision related to health and safety under Factories Act. Just now we discussed what are the health measures and what are the safety measures. Now, how strikes and lockouts are considered as weapon of the collective bargaining. Classify the different types of strikes. We have discussed now strikes in detail. You can go through the study material, various kinds of strike. There, slow down strike, pen down strike, all these type of strikes are there. You can go through the study material. Next is case study. You can say in this case study that Mr. Balwant, an old man, by a registered deed of gift, granted certain landed property to Miss Rima, daughter. By the terms of the deed, it was stipulated that any annuity of 20,000 should be paid every year to Mr. Balwant of this. Someone expected. What is the question? With suitable explain with the suitable arguments. Here, if you know the what is agreement, what is a contract, what is the written contract, what is valid contract, then only you will be able to write the answer. It is little will enlarge this one.
What are all headings to be written under for this question, sir?
First of all, you have to identify the problem. What is the problem? Here we see Mr. Balwant, an old man, by a registered deed of gift, granted certain landed property to Miss Rima. It's very small. I'll just enlarge it. I'll see. Can you read it? This one.
Yes, sir.
Okay. The Mr. Balwant, an old man, by a registered deed of gift, granted certain landed property to Miss Rima, his daughter. What he has done? He has given the deed of gift. By the terms of the deed, it was stipulated that any annuity of rupees 20,000 should be paid every year to the Mr. Sawant, who was the brother of the Balwant. So Miss Rima, she has to every year she has to pay 20,000 rupees to Mr. Balwant. On the same day, Miss Rima made a permission to Mr. Sawant and executed in the favor of the agreement to give effect to the stipulation. So Miss Rima failed to pay the stipulated sum. In an action against her by Mr. Sawant, she contended that since Mr. Sawant had not furnished any consideration, he has no right of action. Examining the provision of the Indian Contract Act, decide whether the contention of Mr. Rima is valid. Now I am leaving to you to discuss. So she says that Mr. Balwant, he has given the gift deed to Rima, and he has mentioned in that one that she has to pay 20,000 rupees annually to his brother. And both brothers of Mr. Balwant, on the same day, Ms. Rima made a permission promise to Mr. Sawant and executed in favor of agreement to give the stipulation. Mrs. Rima, she has given the agreement to Sawant also. Mr. Rima failed to pay the stipulated sum in an action against her by Sawant. The contended that since Mr. Sawant had not furnished any consideration, he has paid. Mr. Thakur, please. Okay. Are you able to understand this one? Hello?
Yes, sir.
Yeah, now you tell me whether she is supposed to pay, where Mr. Rima failed to pay the stipulated sum. In an action against her by Mr. Sawant, she contended that since Mr. Sawant had not furnished any consideration, he has no right of action. Is it right or wrong?
Sir, in this particular case, there are two agreements basically. First is in form of gift deed, and second is form of agreement executed in favor of Mr. Sawant. So
Yes.
she is liable to pay.
Yes. So like this, if you are able to understand that what is the what is an agreement, whether there is a valid agreement or not, whether a valid contract or not, so all these things, then only you will be able to reply. In some of the case study, there will be at the end there will be a question. In some of the case study, directly they have here gonna explain with the suitable argument. You need to argue that whether the she is supposed to pay or not. Okay. This one of the example. This is what the law contract is given. Company law it may come. Sometimes law contract also it comes. So based on that, you need to write the answer with suitable reason. No, here they have given another one is the other one I have not uploaded. Okay, is it clear? Or any doubt, anything you want to ask? I think time is over.
Sir, can you share the PPT?
Yeah, I will share the PPT today. Those who have
Please share this question paper as well.
sorry,
Please share this question paper as well.
question paper you can go to the our website. It is there already there.
Okay. Okay.
From there only I downloaded just now. So website it is already there. 2021, 22, 2 years question paper, or 23, 24, 2 years question papers are there.
Sir, could you please ping the link in the chat?
Just a second.
Yes, please.
I'll give the link of all the question. Management concept, manager, accounting for manager, business environment, research methodology, organizing behavior. See, January, December 2023-24, both the question papers are there. Give the link.
Yeah, that link, yes. Thank you, sir.
Okay. All of you can copy the link so that you can get the question papers for your practice.
Sir, you can share the PPT in the chat itself. We can all download it.
Here, I don't know how to attach this one in chat box. Is there any provision for attaching in chat box? Anyone?
Sir, there is no option to attach in chat box.
Then
Instead, you please share the mail PPT to this mailbox, mail ID. We
Yes.
all mapped here, December 2024 registration.
No, those who have sent me mail, I will share with them.
Nizam,
Tell me.
this Google Classroom only created. So you can upload in the Google Classroom. The students can download from that. You can ask Satish tomorrow. You say send your PPT to Google Classroom.
Yeah. That will share in Google Classroom. Otherwise, all of you can get it. Otherwise, those who have sent mail, okay. So thank you very much. Wish you all the best for the examination.
Sir, share your mail ID, please.
Is there in PPT? Okay. I'll just